Good morning, students. So today we're going to talk about how the law affects student records, and in that we're also going to cover defamation and what defamation is and the right to privacy. And in doing so, we're going to look at three specific areas: the careful handling of records, which will take most of our time, the protection from defamation, and then finally the right to privacy. These are the three areas that we'll see where the law protects students in the courts. The main thing that we're dealing with here is called the Family Educational Rights and Privacy Act, or FERPA, which was passed in 1974. It is better known as the Buckley Amendment, or I should say also known as the Buckley Amendment. And basically we're going to see that this is the law that says what schools can release to the public or make known to the public regarding students' records. And keep in mind here that when we're talking about schools and records, we have all kinds of records that we keep on children, from grades to health records to court documents. All these things go in their CUME files. And this is what we're talking about here. Who can we show these records to? Who can view them? When can they view them? That kind of thing. And all this is regulated under FERPA. So some basic rights that go under FERPA. For the parents, first of all, parents have the right to inspect all records that the school has on their child. If they want to inspect those records, they can inspect them. If the school doesn't have them accessible, the school has 45 days to get those records together for parents to inspect. They can challenge the accuracy of records. Here, especially when we're talking about grades, because that's probably where you'd come into this mostly, is challenging grades. They can't simply challenge a grade. What they can challenge, though, is how the grade was figured, if this was intended to be what the grader wanted, that kind of stuff. Maybe there was a problem in the math, but they can't challenge a grade simply saying this grade is not fair. FERPA doesn't give them a legal right to challenge into that. They can still challenge it, and they probably will, but FERPA doesn't cover that. Parents have a right to release records. We'll see in a second that schools have to communicate to parents what they consider their public records, or what we'll call a directory. And if a record is not in that directory, then a parent has to be consulted in order to release that record. And then finally, students have parental rights once they reach the age of 18 or upon entry into a post-secondary school. And this really comes into play, obviously, when the child is a senior and they hit 18. And really where I've seen this, or the only time I've really seen this be an issue, is a child who's in special ed who reaches the age of 18. And it really hasn't been an issue. That's just the only time I've ever seen it brought up. So those are some basic parental rights under FERPA. Under FERPA, school districts, if they violate the law, in other words, let's say they release records to Johnny's cousin, and Johnny's cousin gets his grades, and he realizes that Johnny's doing poorly, and he goes and causes a family feud. The parents can sue the school under FERPA, saying that this was a violation of FERPA. But what happens to the school is the parents can't seek any damages as a result of that. What happens to the school is they lose federal funding. FERPA is a federal law, And in Oklahoma, the average school district gets about 10% of its federal monies, or monies from the federal government. And so therefore the school is in danger of losing those monies. And so that's what happens to the school district. They can release these records to the parents of a child, or somebody who is financially supporting the child. FERPA requirements: school required to publish public records policy, reasonable time frame for parental requests. Like I said, that reasonable time frame is 45 days or less. So if the parent asks to see all their child's records, or his or her child's records, then the school has up to 45 days to gather those for the parents. The required published of a pupil records policy. This is what we're talking about here, the directory information. And in this, the school may include, does not have to include, date and place of the child's birth, the major field of study, participation in activities and sports, date of attendance, degree and awards, most recent institutional attended. That's what the law says a school can release without parent notice. Not all schools do that. Some schools limit that and cut that down. One of the things, and this is really the only area that I've come into, me personally come into contact with any of this kind of information, is I had some parents who did not want their child's records released to anybody. Not only that, they didn't want their child to appear in the yearbook or have their picture put on the website. And so that was a little bit a different case, but that obviously falls under FERPA here because the parents made that known to the school that they did not wish any of this to be released. And especially under the degrees and awards, because it's common for schools to list students who are on the principal or superintendent's honor roll, or at the end of the year list, make a list of awards. These parents did not want their children's name in any of those lists, so that was something that we had to abide by. Legally, the law says that no parental consent is required on the next two slides for these things. If other school officials in the system who have a need to know, they have access to those records. Other schools in which students seek to enroll. For example, that other school officials in the system, this is why you as a teacher have access to a cume folder of a child in your class so that you can see what the child has previously done. You can look at test scores and things like that. There's no need for parental consent on that. Other schools in which students seek to enroll, we were in the habit of having parents sign a waiver saying it's okay for us to send the child's records, but technically by the law here, this says that's not necessary. But we did that more than anything. We did that simply because we wanted to know where the child was going to school, so that we had assurance the child was not truant, and that if nobody sought the records within the 10 days, the child being out of school, we could call the school up and find out if the child was truant or not. So that's why we did it. It wasn't because of legal reasons. Authorized governmental entities such as State Department of Ed, financial aid offices when the student is seeking financial aid, government officials collecting data required by law prior to November 19, 1974. Never came into contact with that. Also, no parental consent is needed for studies by educational institutions if the personal identification of students is destroyed after the info is no longer needed. Though at NSU, if you have taken ed research, or probably actually better advanced ed measurements, you know that in advanced ed measurements we require parental consent on these issues. but technically by law it's not necessary. Accrediting agencies, these are the agencies who accredit school institutions, parents of the dependent child, or the Secretary of Education. If Arnie Duncan were to ask for a child's records, then we could give them to him without asking the parents. Personally identifiable information should be kept confidential unless the consent of the parents or the student is over 18. At that point, it's the student's right to say if that information is to be released or not. The right to inspect the records, as we said earlier, is a right that every parent or guardian has. And the record keeping with enough detail to be able to find information by the parents. Staff members with access to records must be identified by title. We always had in 2 spots within the school on my office door a specific list of people who had access to records by their title, and we always kept our records in a safe because it was a fireproof safe, and we also put the notice on the safe. Record of access signed by staff member when withdrawing information, and again we said the right to appeal content accuracy by parents with appeal process if denied. I'll make one note about the record of access. This generally is done concerning special education records specifically. For a teacher to simply look into a child's CUNY folder, we never required them to sign in for that. But when you get into the schools, and obviously those of you who are in the school system and especially have worked with special ed, you know that there is that paper to sign saying that you have accessed the records. The law has determined that there are certain type of records that are non-school records, and in this case, what FERPA says is that non-school records include treatment records, personal notes, notes used to jog memory that are not accessible to others, and information through conversation and personal contact. These would be notes and so forth that teachers may make back and forth, or the principal may write down about a student. For example, if one of the things when I used to investigate student activities to find out what happened in an incident, when an incident arose at school, I obviously took notes as I went. Those would be considered non-school records here. Now, on a side note, I had somebody tell me once that even though FERPA says these are non-school notes, that states can upgrade these. And with that in mind, I always tell people don't write anything in a note that you would not be willing to slide over and share with the person you're writing about, just in case those got into a court battle. One thing I need to add here real quick that I just thought about. Talking about parental rights, one thing you need to remember, obviously with the divorce rate so high in the country, especially here in Oklahoma, right now probably odds are the majority of your students are children of divorce. Unless the one biological parent brings a court document stating that the other biological parent does not have access to those records, you cannot deny a biological parent access to his or her child's records. And I actually come across this a few times, and probably the last time that I did it, most of the time it's pretty straightforward. You get a copy of the divorce decree. You use that, tell a parent when they come up and say, hey, I don't want my ex-husband to be able to have access to these records. Fine. You tell them your ex-husband has access unless you give me a copy of your divorce decree that says he does not. And I've had parents who lived out of state and asked to be sent copies of report cards, any disciplinary actions, anything that I sent to one parent, the out-of-state parent, had asked for a copy of that. And so we abided by that wish. The last parent I had, though, this particular woman was so against her ex-husband that she came up and told us that he had no right to the records. And we said, well, we need a divorce decree saying that. And she said, fine, I'll get it for you. She brought us the divorce decree, but the divorce decree in there said nothing about the husband abolishing his rights. If anything, I remember they even had joint custody. And so he obviously did not abolish his rights with the parents sharing joint custody. And so we explained to the mother that this was the case, and that as long as the dad asked for the records, we had to legally send them, and that her divorce decree did not prevent him from getting those. And she had a hard time accepting that, and I didn't get to the point where I told her, maybe it's the anger you have towards your ex-husband, but needless to say, we still continue to mail him everything that was sent home. This particular child, to no one's surprise, is going through a rough area. As an only child, his parents are divorced, and apparently it was a bitter divorce. And so I had a lot of discipline referrals on this child, and so I mailed them to the dad. And every time I got to the point on this particular parent, every time I emailed one parent, I carbon copied the other so that they could see I was communicating with both. But anyway, just keep that in mind. So one of the provisions of No Child Left Behind in the National Defense Authorization Act for fiscal year 2002 said that high schools are required to provide military recruiters access to secondary records and directory information on students. And that had not been that way up until that point. Individual rights to damages. Injunctive relief is simply stop doing the action, and the denial of federal funds to school districts. So like I said, if a school district violates FERPA and releases records, this is what can happen to the district. The injunctive relief is the cessation of releasing the records. And then the bigger punch comes from the denial of federal funds if it made it to that point. So what are the individual rights to damages? How do individuals get damages in these kinds of instances then? A case of Gonzaga versus Doe talks a little bit about this. Schools do not pay damages to aggrieved students or parents. It does not permit a private cause of action whereby a student or parent could bring an individual action for damages. In other words, it's saying that there are no punitive damages here allowed to parents. The natural parent has a right to review the student's records unless prohibited by a court order. And here is where I said you have to have that divorce decree saying that parent does not have access. Otherwise, any biological parent has access and must give full rights to either parent. The exceptions being the court order, state statute, or the legally binding document. Divorce decree is going to be the main one that you deal with. Custody papers. In the custody papers, they're going to have to say that parent does not have access to those rights. Just as they do in the divorce decree that they do not have access to the rights. If they simply say that Mary has full custody of Johnny, and that Johnny's dad, Johnny Sr., does not have full custody, that in and of itself does not deny Johnny Sr. the right to see the child's records. Okay, so it has to be pretty specific, and to be honest with you, I don't remember. Maybe one or two, I'm trying to think, that were bitter divorces. And one, I think, had a case where the father went to prison and was denied access to the records as a result of that. But generally, the biological parents are going to have access to records. How about grades? When do grades become record, and can we post grades for students? The answer is yes. If the grades are scrambled, in other words, if they're not in alphabetical order, and or if the names are deleted, so that we don't have identifying so that it's not a way to identify who the students are. This was a case here in Oklahoma, obviously Owasso versus Falvo, dealing with students' grades. And this case questioned whether or not students could grade each other's tests or homework, for that matter, in class. And the courts ruled that this was a legal thing to do for students to grade each other's work. It said that the students' papers were not maintained by the school, and therefore, as a result, they were not educational records. They had not been collected and recorded in the teacher's grade book, which does become an educational record, but up until that point, they are not educational records. And therefore, the student is not acting on behalf of the school by maintaining these records. It is legal to do this. It is legal to have students grade each other's papers. The court said that by not allowing this would impose a substantial burden on teachers across the country, and it would force all instructors to take time which otherwise could be spent teaching and in preparation to correct an assortment of daily student assignments. And so, again, the case Owasso versus Falvo from 10 to, I guess, 12 years ago now or so, said it is illegal to have students correct each other's work in class. Defamation. Defamation comes in two forms, as we're going to see. Words are defamatory if they impute to another dishonesty, immorality, vice, or dishonorable conduct which engenders an evil opinion of one in the minds of others in the community. There's a distinction here, though, between defamation and criticism. A true critic never indulges in personal ridicule but confines his or her comments to the merits of a particular subject matter under discussion. Criticism is criticizing the truth, and the truth in and of itself is not defamation. As we'll see, defamation deals with telling lies. So what if you're telling the truth? And we'll talk about that in a second. That's when you become a critic. And a critic, as the text says, a true critic doesn't indulge in those personal ridicules but sticks to the facts. So as I said, defamation comes in two forms, in libel and slander. Libel is the written form, and we normally think of written being published, but it can be, as these other things say here, notes, signs, marks, movie reels, videotapes, pictures, or effigy. I've never seen anybody burned in effigy, though I think I had students probably wish they could burn in effigy, but that's fine. Must hold a person up to ridicule, contempt, disgrace, shame, or obloquy, or condemning, in other words. And the thing about libel, again, it has to be false. It cannot be the truth. If it's the truth, it's not libel. Unprivileged information and malicious to be actionable. So those are the definitions of libel. It has to be false, unprivileged information, and malicious. in intent. Slander, on the other hand, deals with spoken defamation. And so two types of defamation, libel and slander. Libel is written or other forms of media, as we saw. And slander is spoken. And there are actually two types of slander. And one you have to prove and one you don't have to prove. Okay. The first one is slander per se. Words which in and of themselves, without extrinsic proof, injure one's reputation. So these are things that you don't have to prove. Okay. Words spoken only to the offended party is not slander, must be a third party. Exists when there is proof that words have been articulated and conveyed. Need no proof of special harm or direct loss, just an impairment of reputation. So these are the four categories that you do not need proof just to show that your reputation has been harmed. So if somebody accuses you verbally or spreads malicious lies, falsehoods, verbally in one of these four categories about you, you don't need proof. That if you have been involved with a criminal offense punishable by imprisonment, that if you've been involved in a crime involving moral turpitude, that if you have had conduct, characteristics, or condition of improper conduct in business, trade, profession, or public or private sector, if you were involved in those kinds of conduct. Or, and you gotta love this one, because this lets you know that this law is a little bit antiquated. The unchastity of a woman. So if somebody questioned your chastity and spread false rumors about that, you would not need proof. I'm assuming that if you were a man and somebody were spreading these same rumors about you as a man, you would need proof. But if the slander does not fit into one of these categories, the idea that you're involved in a criminal offense, that you were involved in a crime involving moral turpitude, that your conduct is offensive, and that you're an unchaste woman, then you fall into what we call per quad slander, and that means you must prove actual damages in order to seek monetary reward. So that's the idea of defamation. Now, the question then becomes who is protected in what they say and in what they do. And so you have a couple of cases here dealing with public officials and public figures. And when do public officials and public figures, if they're fulfilling the duties of their job faithfully, can they be sued for libel or slander? And the courts have ruled on this, who public officials are. And the New York Times versus Sullivan case deals with this a little bit and says that public officials cannot recover damages for defamatory falsehood relating to their official conduct unless the proof that the statement was made with malice, with knowledge that it was a false statement, or reckless disregard if it was false or not. So there are some protections here for public officials in dealing with their conduct and whether or not they can be found guilty of defamatory actions. Now, keep in mind the exceptions here. It goes back to the idea of libel and slander in itself. This statement was made with malice. Again, if you make a malicious false statement, then you're going to be held accountable. If it's an accident that you did this, then that would exclude you from this rule here. If you thought it was a true statement and you simply said it as truth, then you can be held exempt from damages. The penalty, the actual damages, general or punitive damages, are not available. And so here you would have to show that you actually had loss of damages, or if a parent were suing, the parent would have to show there were actual loss of damages and that the school official made these statements with malice. They were false statements. They knew they were false, and they had a complete disregard for the truth. And if a parent were able to show that, the parent would then have to show actual damages in order to recover some kind of damages. So who are public officials then? This has gone a little bit, has been expanded upon a little bit, as we'll see. Elected officials, amazing that elected officials fall under this category. I think the reason we don't see, and I'm being cynical here, so bear with me, I think the reason we don't see elected officials suing for defamation of character is because they would have to be innocent themselves. And at some point, I think that public officials tend to violate that law. Again, I'm being a little cynical, not completely, on that. Superintendents are public officials. Principals can be, depending on their role. Coaches are public officials, but teachers are usually not public officials unless they have won fame for some reason or another. And this is why we see coaches up there specifically pointed out. The way that coaches and teachers become public officials, and this is almost on a case-by-case basis, if I understand it correctly, is that if they are in the public eye enough. So who defines enough? Well, the court's going to define enough. But if they're in the public eye enough, then they can become a public official. Okay. Otherwise, they are not public officials. They become public figures. And here we see the case a few years after Sullivan of Curtis Publishing Company versus Butts. And this says someone who injects him or herself into an ongoing public controversy and tries to impact the outcome of that controversy becomes a public figure. And so here we see a teacher possibly moving into the realm of being a public figure, even though in their traditional role they may not be a public figure or an official, but by interjecting themselves into situations and trying to impact the outcome, they can become public figures in that sense. And as we said under here, they can be considered in the midst of a case involving falsehood statements. The truth, we said again, by definition, defamation of character is spreading falsehoods, whether it's in the written word or the spoken word. So therefore, truth in itself is not defamation and is the best defense against defamation. The burden of proof here is on the defendant if you can show that what is being said is true, then that takes away the whole case of defamation of character. Absolute privilege. Absolute privilege means that you're going to be held against prosecution. People who enjoy absolute privilege right offhand are judges, attorneys, certain other public officials, witnesses in court, when they are involved in the judicial, legislative, or executive proceedings. Again, I go back to my cynical example of congressmen. I don't think that all their comments are made in legislative proceedings, but maybe I misunderstand. Absolute privilege does not extend to educators, teachers and administrators, they have what we call conditional privilege. And they can be exempt if their actions are made in good faith, honest belief that the information was true, and in response to legitimate questions from people with a right to know. And in one of the videos that goes along with this, you'll see an example, a little skit, where a teacher violates FERPA because the teacher was spreading stuff to another teacher who did not have a right to know. I've also heard of teachers who discuss students in Walmart with a parent discussing multiple students, which is a clear violation of FERPA, and that teacher would not have conditional privilege under this definition because it was not a response to a legitimate question from people with the right to know. In other words, that parent had a right to know about her child, not about everybody else's child. So just keep that in mind when you're discussing students and reports and conduct and so forth. Parents have a conditional privilege as well, meaning that they cannot be held responsible for libel or slander unless, again, we go back to that falsehood, statements are untrue with actual or expressed malice. When it comes to teachers, in the example I used about talking to the parent, a teacher is generally going to find themselves safe if they hold the belief that what they're saying is true and it's the best interest of the school and the student. But it also goes back to that idea of who has the right to know. And so these two bullets here, not germane to the subject matter or occasion, volunteering excessive information not bearing on the situation. When those things come into play is when that teacher talks about other children in school and how they relate to the parent's child in question. Those kinds of things are beyond the scope of the teacher's right to talk with that parent. And in doing that, the teacher can find themselves in trouble, violating FERPA, and possibly defaming the student through slander. Teacher's legitimate inquiry protected if the communication is given in response to a proper inquiry. Again, the teachers have right to records. They have right to discuss issues with parents and talk to parents. And at some point, sometimes things are miscommunicated, and it goes back again to that idea of falsehood. If it was conveyed in an honest, forthright manner, then it's considered to be a legitimate inquiry. And finally, the last slide here is the right to privacy. And all this is the underlying rule here, dealing with FERPA, defamation of character, whether it's libel or slander. All this relies on this idea of right to privacy. When a teacher or school personnel violate this right to privacy, then it flows up into those other areas of FERPA or into the area of defamation of character. But every student has that general right to privacy as a right when they get into your building. That's why FERPA requires schools to say what is included in their directory information, and information beyond that will require the parental consent. So what then is an invasion of these rights of privacy that could result in a violation of FERPA or a violation or a defamation of character? The unreasonable intrusion upon the seclusion of another. In other words, if it's, teachers asking about students, talking about students when it doesn't deal with academic issues would be an unreasonable intrusion upon the seclusion of another. Appropriation of the other's name or likeness, unreasonable publicity given to the other's private life, publicity which unreasonably places the other in a false light before the public. All of these fall under an invasion to one's right to privacy in the school setting, and as a result will generally end up as a violation of FERPA or a defamation of character. So hopefully that gives you a little bit of information dealing with students' records. And it's not so much the records here that I would say, as a former administrator, I had the most issues with. It was really the slander and the talking about students when it's not germane to the subject. And so that's what I would say is the most important thing to keep in mind. So with that, I wish you good luck as you move towards your quiz dealing with students' records.